So Amber Heard is changing her legal team for her appeal. Is this significant? Well, no. But on the other hand, yes. Let's talk about it. So in and of itself, the fact that Amber Heard is getting a new legal team to handle her appeal is not really that significant. It's not unusual to make a change at this stage in a case. And there's a few reasons for that. Appellate work is a very different skill set than trial work. In trial, your job is to try to persuade a jury of what the facts are. In the appeal, your job is really to try to persuade the judge what the law is and why the law favors your client in this particular case. So it's less of a type of practice where you focus on the evidence, the inferences, the proof, and much more of a practice where you're very focused on the rules and what the reasons are for those rules, how those rules have been interpreted in other types of cases with different factual scenarios to give guidance about how the law should apply in this particular case. So it's a different skill set, and it's also often helpful simply to just get a new pair of eyes on the case. The problem with having gone through a trial process is you've often become far too familiar with the case to really be able to see it objectively. You've been too close to too many of the details. And so it can be very difficult to step back and reflect on that in an honest and insightful way about what went wrong, what arguments should you have made, what arguments didn't go in your favor that should have, and those types of questions that are going to come up in an appeal context. So the fact that she has chosen new lawyers to handle her appeal is not in and of itself particularly significant. But there are some things about the manner of this change that I personally find quite telling. So the first thing that really caught my attention here was the lawyers that she chose. So Amber Heard has hired David Axelrod and J. Ward Brown from the law firm of Ballard Spahr. David Axelrod gets the first billing, so we'll look at him first. But I have to tell you, in my opinion, he looks kind of like a decoy to me. He's advertised on his biography as a first-chair litigator, so this is a trial guy. He's a former federal prosecutor. Again, that just emphasizes a lot of experience trying cases in the courtroom, but not necessarily bringing the type of skill set that you need in the appellate process, the research, the writing, the analytical types of skills. So the guy who's worth paying attention to is the gentleman with the second name here, J. Ward Brown. Mr. Brown has quite an impressive resume when it comes to litigating legal issues for media defendants. So he has handled a lot of defamation cases. He's also handled a lot of freedom of information cases, situations where media outlets are attempting to obtain information from the government to assist with their reporting. So his work shows a real familiarity with the requirements of the law, the First Amendment principles, the defenses to defamation, these basic legal questions that are really where the meat of an appeal is going to be found. So on its face, then, this choice of J. Ward Brown to represent her is really a power move by Amber Heard. He has represented a large number of media defendants. Of course, what got the attention from the press release was his representation of the New York Times in defense of the recent defamation lawsuit that had been brought by Sarah Palin. But he's got a wide variety of other media clients as well. He's represented NBC, CBS, Netflix, CNN, Reuters, Korea Times, uh, just all kinds of different media organizations. And his work has included both defamation defense as well as information gathering, freedom of information types of lawsuits. So, this is somebody who we can expect to be extremely familiar with the law that governs media publications. So, a common question that I got from people when this news came out was, oh my gosh, what does this mean? Does this increase her chances of winning? Or are these guys gonna be able to win this thing for her? And so I do want to assure you that even very successful, very high profile attorneys will lose cases when the law is not on their side. And so, just by way of a recent example, Mr. J. Ward Brown, who is apparently quite an excellent attorney with a very good record, he did recently lose fairly big in the Supreme Court of Nevada. He was involved in a lawsuit that Steve Wynn, who is a hotel owner and public figure involved in libertarian politics and that type of thing, he sued the Associated Press for defamation over an article that the AP published that reported on allegations a pair of women had made to Nevada law enforcement officers, claiming that Steve Wynn had sexually assaulted them about 50 years ago, back in the mid 1970s. So, for a variety of reasons, the police did not take any action on these reports. They were well beyond the statute of limitations. So it was basically just a situation where they acted like a note taker, like a documentarian, to create a record of the fact that this report had been made, but otherwise not do anything with it. So the Associated Press got a hold of this document, they published the allegations, and Steve Wynn sued them for defamation. So in this particular case, Mr. Brown argued that the report was covered by the fair report privilege. And the fair report privilege is basically a doctrine that says that when official action is taken by a government or a public agency, that the public has an interest in being able to monitor that and being aware of it. And so they have to have freedom to be able to report it, even if the underlying information is not itself true, because that's an important part of being able to evaluate how the government is doing its job. Is it acting appropriately? So in this particular case, the Nevada Supreme Court rejected the application of the fair report privilege. They said that this was not a situation where the law enforcement was taking any type of official action with this report. So there's really nothing for the public to be interested in monitoring. Instead, they were essentially a glorified tape recorder to just take down this information, turn it into a record, and not otherwise do anything with it. So under those circumstances, the Nevada Supreme Court held, no, this is not protected. This is not the type of document that the public has a significant interest in being able to know about. They are essentially just allegations that have been made that are not founded. So ultimately, this was a loss that he took back in 2020. Now, I say this not in any way to criticize Mr. Brown, but simply, like I said, to point out that when the law is not on your side, you're not going to win, even if your reputation is stellar, even if you're considered one of the authorities in this particular area. So it does happen, and there is certainly a chance that it is going to happen in this case. So another thing that stands out about Mr. Brown and his background is the fact that his representation has tended to focus on these media defendants. And so it creates a different set of implications than representing the original source of the information. So this ties in with the actual malice standard, the requirement that a defamation plaintiff has to prove that the person who published the statements did so knowing that they were false or having such significant doubts about their truth as to effectively believe that they're false and nevertheless proceeding to publish them. So it's a very, very difficult bar to be able to clear with a media defendant. And a lot of Mr. Brown's success has come from being able to wield this actual malice standard at various stages of the case. That, as we saw, was the outcome recently with the Palin versus New York Times case. But he's had a number of other cases as well where he's had similar outcomes in being able to get the case thrown out on actual malice. And that's because reporters are generally allowed to take information from their sources, and unless they have specific reasons to disbelieve it, then that's a situation where they weren't there. They don't necessarily know whether the information was true or false, so they do have some entitlement to rely on what they were told. But having said that, in situations where the media did have reasons to believe that the information that they were publishing was false, that is not necessarily a shield to actual malice. And so this came up in a case that Mr. Brown was involved in where he represented Al Jazeera America. And in this case, they had published a story, a documentary that was kind of this hidden camera expose on the use of performance-enhancing drugs in sports. And so they had basically made contact with this individual who had claimed to be a supplier of steroids and banned substances to a variety of athletes. And in the course of the filming, he named 2 specific baseball players as clients that he had provided substances to. Before the documentary was even released, the gentleman recanted. He said, basically, you shouldn't publish these statements. They are not true. And Al Jazeera went forward with the documentary as it had been originally filmed and produced. So this was a situation where, because the media defendant had a specific reason to believe that the information they were putting out in public was not true, actual malice wasn't going to protect them as a matter of law in this particular situation. So that was another case back in 2017 that Mr. Brown was involved in, was not able to win that immediate success on the law for his media client. So if media clients get a little extra protection in the defamation context, that is very much not the case for the original source of the information, because that person is the one who knows whether they're lying, whether the things they're reporting are truthful or not. So representing Amber Heard is going to be quite a different proposition from a legal standpoint than representing these media defendants that have made up the bulk of his clientele. So if the choice of Mr. Brown reflects a real in-it-to-win-it strategy by Amber Heard, that strategy is really substantiated by the statement that was released by Ballard Spahr. And so their statement reflects his experience with First Amendment issues. And they stated specifically, "We welcome the opportunity to represent Ms. Heard in this appeal as it is a case with important First Amendment implications for every American. We're confident the appellate court will apply the law properly without deference to popularity, reverse the judgment against Ms. Heard, and reaffirm the fundamental principles of freedom of speech. This is an argument by an attorney who intends to win the case. And the reason why I say that is because he is clearly doing what the appellate lawyer needs to do, focusing on the law, focusing on the principles. That is where you win appeals. I'm going to talk about this more in a future video. But for now, all you really need to understand is that the facts have always been the big hurdle for Amber Heard to get past. The facts do not favor her. All you have to do is listen to a small selection of the many hours of audio recordings that were admitted as exhibits in the trial, and that becomes very crystal clear. This case was always meant to be litigated on the law, not on the facts. And so with that in mind, I do find it very interesting that we received this second statement, not from the attorneys, but from an unnamed spokesperson for Amber Heard. That statement says, when it comes to protecting the fundamental right of freedom of speech, we look at the jury's decision to paraphrase a famous quote, not as the beginning of the end, but merely the end of the beginning. A different court warrants different representation, particularly as so much new evidence is now coming to light. This is self-evidently a PR statement, not an attorney statement, and certainly not a winning attorney statement. Because of that final little clause there, so much new evidence is now coming to light. So we can put aside the fact that we've been hearing about all of the mountains of evidence for 6 years now that has never materialized. There is no more discovery happening. There is no new evidence coming to light. We can focus on the fact that new evidence taken in a vacuum is never an issue on appeal. Appeal is a review process. They're looking back at what already happened to evaluate whether there were errors in the legal rulings throughout the case. So it is not a process of we're going to go back and relitigate liability. We're going to substitute our judgment for the jury's and decide whether we think they got it right or not. That is very specifically what the appeal is not about. But we can kind of see from this statement that, boy, that sure is still what Amber Heard wants it to be about. And to me, this signifies a potential crack. What is most telling about these two statements is simply the fact that there are two of them and that they do not reflect a cohesive, coherent strategy for how this appeal is going to be won. If I can summarize the statement of the attorneys, their statement is essentially, even if Amber Heard lied her ass off about Johnny Depp abusing her, legally, because of First Amendment principles, it should not be actionable. The bar for being able to hold somebody liable for their speech is so high that even though she made these false statements and the jury found actual malice, it doesn't satisfy the legal requirements. But that is not and never has been enough for Amber Heard. No, she has from day one had the opportunity and the ability to win this case on the law, and she has insisted at every turn to her own destruction at litigating the case on the facts. And so her statement, her PR statement, clearly indicates she is still very focused on trying to litigate her innocence. And so I have to wonder if that is going to pose a problem for this new representation. If we go back and look at Mr. Brown's bio, one of the things that stands out to me is a testimonial that is published that describes him as a lawyer who delivers continuously high quality service, possesses impeccable analysis and impressive writing skills, and has a friendly, approachable, and attentive demeanor that sees clients wanting to use him exclusively. Look at his picture. He looks like a nice guy. He's described as a nice guy. His skills paint him as somebody who is earnest, serious about the law, and good at what he does. So I have to wonder if he's ever handled a client like Amber Heard before, and if he really knows what it is that he is getting into with this case. If this statement by Amber Heard's spokesperson is an indication that Amber Heard is going to continue to insist on relitigating the facts of the case on appeal, this attorney, I'm here to tell you, knows that is a losing strategy. And so it's going to be very interesting to me to see if he's going to be able to stay the course, to stick with what could give Amber Heard the best chance of winning her case. Or is he going to succumb to the pressure of what she very clearly wants him to do, just like she wanted Elaine to do, to pursue this losing strategy of trying to prove her innocence on the facts? Time will tell, but I'll be interested in seeing how that develops. As many of you know, from a professional standpoint, appeals are my wheelhouse. This is what I've been doing for the last decade. It is all that I do these days. So I'm excited in many ways to see the case enter this stage of the process. So I have received a lot of additional questions about the appeal, what types of arguments might come up, what sort of significance is there to potentially this throwing Elaine under the bus. So I am going to be addressing those in future videos. Stay tuned, and I will see you next time.